Yeah, so my name is Eric Dresser. I'm the Executive Director of Hingham Community Access and Media, the organization that is broadcasting this meeting tonight. You've probably tuned in and caught a meeting somewhere here and there on our channels or on our YouTube page. Just wanted to introduce myself again, my organization, so that if any of you, for your organizations, want to request coverage, you're familiar with who we are and how to do so. I guess we can have some cards available at the end of this meeting in the back so you can contact us, but you can go to our website, hinghammedia.org, and you can click on the Participate tab and request coverage for your meeting. We do ask that you try to do that 5 days in advance, just so that we have time to get our resources and staff into place to get your meetings covered. But we're very happy to do so and keep everybody informed about what's happening in town, both in municipal meetings as well as any events going on in the community. So with that, I'll give it back to Ted.
Thank you, Eric.
Thank you.
Thank you all for coming tonight. I have David Giannotti here from the State Ethics Commission. David is head of the, I think his official title is Chief of Public Education. He heads up their education division. Very engaging. We just went through a session a little while ago, and David will afford an opportunity for questions and answers. And you'll be much happier to see David in this setting because now, as he's educating, it's a little different from what he did previously, which is if you had met him, he was enforcing. And so that probably wouldn't have been the best meeting in the world for you if you were meeting him prior to today, but today you get to see him in a much different setting and enjoy a very good and lively discussion. Thank you.
Thank you, Ted. Okay, thank you, Ted. Thank you to the town. Thank you all for coming. We are being recorded, but don't let that inhibit you from all of the questions I'm sure you have. My name is David Giannotti, and I'm the Chief of Public Education and Communications for the State Ethics Commission, and I'm here to talk about the state's conflict of interest law and how it applies to us as we do our jobs as municipal employees. Just a couple of ground rules. I am not an attorney, so I'm not here to give out legal advice. If you have a question about the conflict law and how it might apply to your specific situation, I would ask that you contact the Ethics Commission and talk to one of our legal division attorneys. We have the person who is designated as the attorney of the day, and their job is to give out legal advice. Also, just understand the Ethics Commission is in the house, so if you have any questions about the conflict law, please keep your question hypothetical or prospective. Please don't tell me that you violated the conflict law or that any of your neighbors did. I'll do my best to give you the information. I will talk about the law in a general sense. I'll try to explain it by illustrating with examples. But you know, I may not have the right answer for you, but we'll give you the information so that you can get the right answer. What we're here to talk about is the conflict of interest law. What the conflict of interest law seeks to do for public employees is to sort of maintain a high level of confidence in government, in the processes of government. There are things that happen in government where that confidence can erode. If people think that public officials are acting out of self-interest instead of the public's interest, confidence in government erodes. If the public thinks that there's a certain unfairness in government, confidence in government erodes. And we're not here to deal with all of those potential situations, but we're here to talk about the conflict of interest law and what the specific compliance rules are when you serve government. So you have a copy of the handout which contains these slides. It's for reference materials. If you have any questions, what have you, we'll take them as we go along. We'll talk about the State Ethics Commission. The State Ethics Commission is an independent state agency. It's a relatively small state agency. We have 5 commission members and 25 staff members in our offices in Boston. The Ethics Commission is an independent body, and its job is to provide advice and enforcement of the state's conflict of interest law. The Ethics Commission is a law enforcement agency because the Commission can impose civil penalties for violations of the conflict of interest law. We don't enforce statutes criminally. That's the Attorney General's job or a district attorney's job. We have one specific mandate where we enforce 2 statutes, administer and enforce. Administer meaning the Commission can give out legal advice on how to comply with the law, can promulgate regulations to clarify the law or provide exemptions from sections of the law. Enforcement means it can prosecute violations and impose penalties. The conflict law applies to you if you are a public employee in Massachusetts at the state, county, and municipal level. You are a municipal employee if you provide services to the municipality, Whether you're a full-time employee or a part-time employee, whether you're elected to a position, whether you're appointed to a position, whether you're paid, whether you're unpaid. Even if you serve in a position that is intermittent or seasonal, you probably are considered a municipal employee for conflict law purposes, if for no other purposes. Even in certain limited instances, contractors, folks that have contracts with the municipality, if their specific services are required to satisfy a contract with the municipality, they could be considered municipal employees for conflict law purposes. We have 3 operating divisions at the Ethics Commission. Mine is public education. We manage the agency's website. If you have a question about a conflict of interest, a lot of times you can go to our website, it's searchable. We have information, educational materials. We have various materials on our website which might help you understand the conflict of interest law. We also have a legal division staffed with attorneys, and their job is to provide confidential legal advice to you, me, and everyone else who's subject to the conflict of interest law. You call up and talk to our attorney of the day. They receive thousands of calls every year. Most of those calls can be resolved in the context of a 5 or 10-minute phone call. Also, they'll email back and forth if you want something in writing. Our legal division will also give out written legal opinions if you need it, but they need a bit of time to turn those around. Most times you call in, you will not be able to talk to one of those attorneys because of the volume of work coming in, but they will return calls. They try to return calls the same day. Sometimes it's the next day. But if you need written legal advice, they need about 4 to 6 weeks to turn that around. So the idea is, if you need a written opinion, don't call in on Monday and say you need the opinion by Friday. That's not going to work for you. I'm sorry, we also have an enforcement division, and that's a division staffed with attorneys and investigators. And their job is to review the 900 to 1,200 complaints the Commission receives every year. Everything that comes in gets reviewed. And we look to the issues. Does it suggest something within our jurisdiction? Are the facts fresh, or is this sort of a stale issue? If we could prove the facts, would it suggest a violation of the conflict law? If so, would it be a significant one where a civil penalty might be imposed if the facts could be proven? And that happens in a very limited amount of instances each year. Of the 900 to 1,200 complaints we get every year, only a relatively small amount are resolved with public enforcement action, only about 24 times a year. The rest of those cases, what happens? They remain confidential. The Ethics Commission has statutorily imposed strict confidentiality rules where we can't talk about all of the work we do. I've been with the Commission a whole bunch of years. Most of that, as an enforcement investigator, I can't talk about 99.999% of the cases I've ever worked on because they were received, reviewed, and resolved confidentially. What we do across all of our operating divisions is we educate public employees about the conflict of interest law. We do it in this context and in the information we present on our website and in our press releases. Our legal division does it thousands of times every year when it talks to public employees about the compliance rules. Our enforcement division does it. And all those cases that are resolved confidentially, and many of them, they're sending out hundreds of confidential letters every year to public employees saying, look, we've gotten this information, we've reviewed it. If we could prove the facts, it would possibly suggest an issue under the conflict law. Here's how the law applies. We're not going to take any formal action in this case. If you have any questions, make sure you take the time to find out how the conflict law applies to your situation. There's our website. On the website, we have educational materials, formal legal opinions. Most of the opinions, or all of the opinions that are issued by our staff attorneys, are required to be kept confidential. When people call our office, say they want to know, has the Commission received a complaint? Are they conducting an investigation? Has so-and-so received advice from your legal division? Our response is we can't confirm or deny that information. We can't confirm or deny whether we've received complaints, whether we're conducting investigations, whether anyone has sought or received advice from our legal division. But there is a limited subset of information that we can make public, and we do, and it's all up on our website. There are instances where it's the Ethics Commission as opposed to a staff attorney issuing an opinion. They do so if there's a novel or complex set of facts and the legal division is really uncertain how to give advice under those facts. It will ask the commission to issue a formal opinion, and those formal opinions serve as precedent, so they're posted up on our website, except that the requester's information has to be redacted. In an enforcement context, all the stuff that we receive and review is required to be kept confidential, except in an adjudicatory proceeding. When the Ethics Commission issues a decision in an adjudicatory case, an enforcement case, if you will, those decisions by the commission where somebody is found to have violated the law and they pay a fine, those decisions are public. They're also all up on our website. Disclosure forms. As I talk about the conflict law, and I'm going to talk about disclosure. Whenever I talk about disclosure, it has a distinct meaning. It means that it's something that's in writing, something that's filed in advance of the public employee engaging in any conduct which might implicate the conflict of interest law. And that written statement that's filed has to be preserved as a public record. Generally, we have areas under the conflict law and under the regulatory exemptions where a disclosure may be the appropriate remedy to a conflict situation. If you are appointed to your position as a town employee or on a board or committee, you are appointed by the selectmen, for example, you have an appointing authority, and you have to file a disclosure to comply with the conflict law or one of the regulatory exemptions, you file it with your appointing authority. They have to keep it as a public record. So if a member of the public or the media contacts the agency and wants to know whether you filed a disclosure, it has to be produced. If you are elected to your position, you file those disclosures with the town clerk, and they're kept on as public records. Also, there are statutorily required education under the conflict of interest law that have been in place since 2009. So in addition to what we're doing, the town will also give you the summary of the conflict of interest law. You have to sign off that you received it, so that if we need to verify that the town fulfilled its statutory obligation to distribute the summary, we can do so. And then there's also an online training program that we all have to complete once every 2 years, and we print out a completion certificate. We turn that into the town as well. I'm sorry to tell you, this does not substitute for any of the mandatory requirements. This is sort of an add-on which gives us a different dynamic to help learn about the conflict of interest law. The point being so that you'll know when the red flag should go up, when there's a conflict of interest, and you'll know how to properly respond to it. But on our website, we have links to the online training materials, the summary of the law, and so forth. If you need to get advice, something that you plan to do or are poised to handle as a town employee, and it implicates the conflict of interest law, and you need to know what the compliance rules are, make sure you get that information in advance of handling the matter as a public employee. Do not handle the matter and then try to find out afterwards whether it violated the law. That's not the way it normally works. But you can call our office, ask to speak to the attorney of the day, and they'll explain to you what the compliance rules are in your given situation. So that's it about the agency. Let's talk about the conflict law. At its highest level, Conflict Law 101. The premise under Massachusetts law is that public employees at the state, county, or municipal level, while they're doing their job, they have to keep separate their public responsibilities and their outside personal interests. Public responsibilities, that's what we do as town employees, whether we serve in town departments or whether we serve on boards and committees. Outside personal interests, what are they? Well, basically the short answer is any component of your private life, who you are, where you live, what your outside interests are, what church you might affiliate with, what nonprofits you might belong to, what outside hobbies you have, who your family members are, who your friends are, what outside business interests you might have. Anytime while you're performing your duties as a public employee, if some component of your private life is going to be impacted or affected by what you do, that's a conflict of interest. But it doesn't mean it's a violation of the law, but what it certainly means is that the conflict of interest law applies to the situation. And so the question then becomes, what are the compliance rules? Well, conflicts basically break down two ways. There are conflicts that feature a financial interest component. Something that you plan to do will affect your financial interests or the financial interests of family members, certain family members, or a business that you might own or operate, or your private employer, or a business partner, for example. And as to financial interest conflicts, the law disqualifies your participation. Municipal employees may not participate in matters where financial interests are affected unless they're appointed to their position and their appointing authority says they can participate. And we'll go through what that process involves. That's financial interest conflicts. And then there's every other kind of conflict. Non-financial interest conflicts. They fit into this other bucket. And as to non-financial interest conflicts, the law says that you can continue to handle that matter as a public employee even though you have a conflict of interest, provided you disclose the conflict first. In disclosing conflicts, it serves to put the cards on the table, to dispel appearance problems that otherwise might arise. That's Conflict Law 101, if only it were that simple. But there are 29 some odd sections of the conflict law with varying degrees of complexity, and we'll try to wrestle with those so that at least you know when the red flag should go up and then what to do about the situation. Several sections of the conflict of interest law deal with gifts. The issue is, as a public employee, can you accept a gift from someone? And when we talk about gifts, we mean an item of value. And we use terms interchangeably: gift, gratuity, expense payment, reimbursement. Basically, when I talk about that interchangeably, it means any item of value, tangible or intangible. Any item of value in any way, shape, or form conveyed from one person to another is a gift or an item of value for conflict of interest law purposes. And there are several sections of the law that concern themselves with gifts. Now, why are those restrictions in the conflict law? Because, as I said, the conflict of interest law and other laws, they deal with maintaining integrity in government, maintaining a high level of confidence in government employees and in government processes. Gift giving involving public employees and the people that they deal with, it tends to erode confidence in government because people will wonder whether the public employee, upon receiving a gift, will continue to do their job effectively and objectively, or instead, whether their judgment is somehow impaired, whether they're going to be favorably predisposed to decide matters favorable to the gift giver. And so the conflict of interest law lays out various restrictions on gift giving to public employees, or items of value conveyed to public employees. The first section being bribery, and that's an easy analysis under the conflict law. The answer is always no. A bribe involves an item of value that is corruptly solicited or received by the public employee, or corruptly offered or given by somebody who's dealing with the public employee. And when I say corrupt, that means there's a string attached to that item of value. There's an explicit understanding that for the item of value, the public employee agrees to do something, to not do something, or there's some collusion that involves a fraud on government. In what we do as public employees, some of the things we do might convey benefits to the people we deal with. Like if you issue a permit, that permit has no value to you, but does it have value to the applicant? Of course it does. Does having an inspection pass, does that have any value to you? No. But does that have value to the person who needs that inspection to pass? Absolutely. So there are things that we do as public employees which might result in conveying benefits to people. The rules are set up so that in government, everything we do follows a process or a rule so that public resources are available to everyone on an equal, open, and fair basis. And things like gift giving can tend to corrupt that process, and so they're restricted under the conflict law. And so bribes are always prohibited. There's no minimum dollar value for a bribe to occur. If there is an item of value conveyed and there is a quid pro quo associated with it, it violates the bribery section. Now, this is the most serious violation under the conflict law. In 2009, the Commission was given expanded enforcement authority to enforce the provisions on the conflict law, where it can now impose civil penalties of up to $10,000 for a violation of any section of the law except for this section. For this section, it's $25,000. Also understand that there are criminal penalties for most sections, violations of most sections of the law. Now, the Ethics Commission is a civil law enforcement agency. We don't enforce the law criminally, but who can? In an egregious violation where a criminal review is appropriate, that's going to be the AG or a district attorney. But for the bribery section, the potential criminal penalty is a $100,000 fine and 10 years in jail. Whereas on the civil side of it, it's the Ethics Commission and the ability to impose a penalty of up to $25,000. And so that's bribery. The next section that deals with gifts and gratuities, what we refer to as illegal gifts and gratuities. This section of the law says that it's a violation for anyone to offer or give to a public employee, or for a public employee to solicit or receive anything of substantial value. And that term substantial value means anything worth $50 or more. So we've all heard about the $50 rule. This is where it's grounded. And it goes on further. An item of substantial value offered or given for or because of some official act performed or to be performed. In other words, it creates a nexus requirement that the public employee is dealing with someone on some official business, and in connection with that process, the person provides the public employee with a gift, a gratuity, an item of value worth $50 or more. Where there is that nexus, that tie-in, it violates the conflict law. And under the bribery section and the gift and gratuity section, both the giver and the public employee can be held liable for violating the conflict law. Now, a gift worth $50 or more given for or because of some official act performed or to be performed. It sounds like it creates a similar situation to a bribe. How do we distinguish it from a bribe? Well, basically, a bribe involves a quid pro quo, where there is an expressed understanding that for the item of value, there will be a specific result. The public employee will take a specific action. In a gift or gratuity situation, that's not the case. There is no quid pro quo. In other words, the public employee will continue to do their job the way they're supposed to, but the gift is given in connection with that whole process. And because gifts tend to undermine confidence, they're restricted, where the $50 rule is in place, saying at a gift worth $50 or more, it's possible for the public employee's judgment to be impaired, therefore the restriction is in place. And then finally, there's a section of the law in the conflict law dealing with gifts which basically says that public employees may not solicit or receive any item of substantial value if it is given for or because of official position. In other words, you're not allowed to accept any item of value worth $50 or more from anyone if they're giving it to you because of who you are as a public employee, because of who you are. Not because you're a great person or you're a family member or a friend, but strictly because of who you are as a public employee. And that's the threshold that we all need to be aware of, because bribes, gifts, gratuity, they involve sort of more serious conduct. But just, you can't accept anything. If somebody that you know in town, but you're not friends, you're not family, but they know you work for the town and they have business matters involving the town, but not with you, they come up to you one day and give you a couple of Red Sox tickets where the value of those tickets is more than $50. And they're giving you those tickets because of who you are as a town employee, you're prohibited from accepting those. Yes, question?
Sometimes town employees are invited to openings of restaurants.
Mm-hmm. Sure.
Businesses, and they have, so there'll be food, wine, that sort of stuff.
Sure.
Same perspective, same ground rule, because, you know, they're trying to get the public employees there.
Mm-hmm.
We're
going to talk about that. There are regulatory exemptions from the gift rules that are available, and we'll go through that. And your question is, you know, if some private party, some developer, some applicant, someone, they complete a project, they're now having an open house, and they're inviting public employees, and they're providing food and beverage, does that implicate the gift rules? It most certainly does. Is it permitted? It depends, and we'll get into what are the circumstances? Because generally the answer is no unless. And in this case, no unless it qualifies under the regulatory exemption. So a couple of examples, I'm not going to go through them, but one of the examples involves an item of value conveyed where it's for or because of some official act. The second one is an item of value conveyed because of official position, just to illustrate that for you. And so we've got you going, okay, bribes of any value not allowed, gifts or gratuities worth $50 or more. So the question then becomes, what about some item of value that's given to you, a gift or what have you, that's worth less than $50? Can you accept it? Well, the conflict law doesn't permit it. It simply doesn't prohibit public employees from receiving items worth less than $50. But it doesn't mean that there isn't a compliance rule in connection with that, because the conflict law says that anytime a public employee is poised to handle a matter and they have a private interest in that matter, they have to file a disclosure to dispel the appearance problem that's otherwise created. So in the context of gifts worth less than $50, let's look at that a little bit. Say I'm a school teacher. I'm a municipal employee. What are my official duties as a school teacher? Well, I teach students. I deal with colleagues. I deal with parents. That whole realm of what teachers do in the course of a day. Those are my official duties. So say one day the parents of one of my students gives me a $40 gift certificate to my favorite restaurant. Can I accept it? Well, yes, because the conflict law doesn't restrict it, but presuming it's not a bribe, and presuming it's not part and parcel to several individual events worth less than $50 that can be aggregated, because then it's problematic, but it's a singular event, a $40 gift certificate to my favorite restaurant. Can I accept it? Yes. Is there a compliance rule? The compliance rule being, do I have to tell anyone I got it? Namely my boss. In this case of a teacher would be the principal. The answer to that exciting question is maybe yes, maybe no. It depends on the circumstances. Every analysis under the conflict law is fact specific, and so sometimes we have to add facts, and in this case there are not enough facts to analyze the issue, so let's add some facts. I get that gift certificate, it's at the end of the school year. The student is moving on to the next grade level. As a teacher, I'm no longer going to have any dealings with that student or the parents. In that instance, a reasonable person couldn't conclude that I could act with bias because I'm no longer going to have any dealings with them. In that instance, I can accept the gift certificate. It's worth less than $50 and it's not a bribe, and I don't have to tell the principal that I got that gift certificate because I'm not being placed in a situation where a person could reasonably conclude that I could be improperly influenced. But what if I got that gift certificate in the middle of the school year? And oh, by the way, the parents have also asked me to write a letter of recommendation because they want to enroll their child in an AP class. And oh, by the way, the parents of all of my other students have also asked me to write letters of recommendation, and I physically can't write that many. In that instance, a reasonable person, after I get that gift certificate, a reasonable person, all of the parents who did not give me a gift certificate, they could conclude that I could be improperly influenced by my receipt of that gift certificate, that I'm going to put that child's letter of recommendation to the top of the list, that I'm going to devote more of my services as a teacher to help that child or those parents. So in that instance where it creates this appearance problem, where reasonable people could conclude that I could be improperly influenced by my receipt of that item of value, I can accept it, but I have to tell my boss, the principal, I have to file a written disclosure that says I got that gift certificate. Now, when do I have to file that disclosure? Well, the law says that any disclosure has to be filed in advance of the conduct. But wait a minute, I won't know that I got that gift certificate until I get that gift certificate. So when do I file the disclosure in that instance? Well, it's not when you get the gift certificate. It's when you are next poised to have to deal as a teacher with the student or the student's parents. When you are next poised to have to take official action, before you do so, you have to file that disclosure. So it's at some point from the time you receive that gift certificate until you next have to take official actions regarding that outside interest that's now created for you, do you have to file that disclosure. And under this section of the law, agencies are free to adopt their own standards. So if I file that disclosure with the principal and the principal says, oh no, we don't allow teachers to do that, and there's a code of conduct for teachers that says, no, you may not accept items of value from parents, well then the agency policy, the agency code of conduct would control in that situation. We have state agencies, for example, while the conflict law has that $50 rule, Massport, a state agency, has a zero tolerance policy. They don't allow any of their employees to accept any item of any value from people that they deal with officially. So we have regulatory exemptions. Over the last several years, the Commission looked at certain situations that might call for public employees to accept items of value worth $50 or more, where they really didn't rise to that big of a deal. It really didn't involve any sort of mischief. Bribery always involves mischief. Certain gifts and gratuities involve mischief. But there were situations where, yes, an item of value was conveyed to a public employee, but if certain conditions apply, there isn't any mischief. It's not a violation of the statute. And the Commission identified certain categories where exemptions from the gift rules might be available to public employees. On your handout in here, I have bulleted categories where exemptions might be available. I'm only going to talk about a couple of them. The first one being the travel expense exemption. You have the opportunity to attend a conference or a seminar or some event that's part of your job. The town can't pay your expenses, but somebody, some host or vendor or some private party says, we'll pay your expenses to attend that conference. Well, before that would implicate the gift restriction. You can't receive anything worth $50 or more that's given to you because of your official position. But there's a regulatory exemption that says if two things occur, you can accept expense reimbursements for your travel expenses, and that can include any expense: hotel, meals, car rental, airfare, any expense reimbursements that relate to your attendance at an event if two things occur. Number one, you file a disclosure with your appointing authority that a private party is willing to pick up those expenses. Your appointing authority then has to make a determination that your attendance at that event serves a legitimate public purpose. And that has to be done in a disclosure form, and that disclosure form preserved as a public record by the agency. If those two things occur, then you can attend the event, you can accept those expense reimbursements without violating the conflict of interest law. To the gentleman's earlier question about these open houses that folks have where they're serving food and beverage, incidental hospitality at events that serve a legitimate public purpose. Wining and dining is illegal, period. But sometimes public employees are invited to events and the host is going to serve food and beverage that's incidental to the event. And that would involve, possibly implicate the gift restriction rules. Through the regulation, the Commission has said public employees can attend those events, can accept the hospitality regardless of the value, but they have to file a disclosure of that hospitality. And they can then attend. Because our legal division over the years would be getting inundated with calls when public employees had the opportunity to attend these events. They'd be saying, I can go to this event, but they're going to be serving coffee and pastries. Do I have to figure out how much a muffin costs to verify that I'm not getting anything worth $50 or more? And we would say you can accept items as long as it's not worth $50 or more, so you're going to have to find out what a muffin costs. But the Commission promulgated a regulation that says you don't have to worry about that. You can go, you can accept the hospitality, just file a disclosure, and then you'll be okay. There's an example of the travel expense regulation for you to review. It's about having some private party, not the town, pay for your expenses. Was there a question?
Yeah. Question. Does it have to be in the context of a reimbursement versus, they just tell you we're going to be at XYZ venue, you don't actually pay out, they just cover the cost of doing that? Is the reimbursement to be able to kind of assess where that dollar threshold is?
Well, they have to be able to, you have to be able to quantify what the expenses are, and whether it's discounted or free admission, that's allowed, or if it's actual reimbursement for expenses you paid, or would they pay the expenses up front, as long as it's disclosed as to what those actual expenses are, because it's a reimbursement, not an add-on. If there's an add-on, that's problematic. Just actual expenses can be paid or waived or what have you. I'm not going to go through all of a description of all of them. These bullet points describe where categories might be available. We have, when they're gifts among public employees, understand that it's possible for one public employee to bribe another, or one public employee to offer an illegal gift or gratuity to another. Example, say I'm hiring for a position on my staff and one of my existing staff members is going to apply for the position and it would be considered a promotion for them. Now, our relationship is such that we might go out occasionally, socially, we might pay for items of nominal value for one another, but this position is open, they apply for it, and in that context, all of a sudden there's a $100 gift certificate to my favorite restaurant in my inbox from this employee. What's the point of that gift certificate? It's not customary to our relationship. All of a sudden this shows up. Might it be an effort to try to leverage my judgment to try to enhance their position? Yeah. So it's possible for public employees to violate the conflict law in their dealings with one another. Unsolicited perishable items. Sometimes we work in town hall and maybe we're dealing with a vendor and they send us a bouquet of flowers, say thank you or what expression of goodwill. We get an edible fruit basket. Or say I work in the DPW and we've got a snowstorm and I call out all the contractors to plow the roads, and so they show up at the yard, they're getting their plow blades installed, they're getting their trucks loaded with sand, and what are they doing? Well, they're bringing pizzas, they're bringing donuts, coffee, what have you, items worth more than $50. So what are we supposed to do as public employees? Do we tell them to go away? Do we refuse it? Well, the commission said in a regulation that as to unsolicited, and that being operative, unsolicited perishable items, it's impractical to refuse or return. So public employees do not have to refuse or return those items as long as they can eliminate the element of the crime, so to speak, that being the $50 rule. So if you receive a bouquet of flowers, an edible fruit basket, or food items, how do you eliminate the $50 rule? It comes to you as the public employee. You can't accept anything worth $50 or more. You can share it with everyone. And as long as you share it with everyone, and not just people you pick, but anyone that frequents the office, including the public, you get those food items, you make them available to everyone generally. You get the bouquet of flowers, you don't take it to your back office, you leave it out front, unless you want to parse out the individual stems and find out how much a mum costs versus a rose or what have you, as long as no public employee receives anything worth $50 or more. You get that edible fruit basket. The law requires that you share it. I would allow a limited window of opportunity to sneak it back to your office to grab those chocolate-covered strawberries out and leave the apple slices for everyone else. But just as long as you don't get anything worth $50 or more, that's the whole intent of that regulation. Any teachers here? Okay, there's a carve-out for teachers. They can accept items of up to $150 as long as on a class gift where everybody's contributing to a gift, as long as the individual donors to that gift are unidentified, because they don't want to put the teacher being in a position of being improperly influenced. They won't if they don't know who contributed. But that's only available for teachers and not for the rest of us. Okay, that's the gift rules. The gift rules. So now we move on to a section we call the Nepotism Section. When you took the online training program, we called it Nepotism and Self-Dealing. Nepotism, you're taking care of friends and family. Self-dealing, you're taking care of yourself. These are financial interest conflicts. The law says as a municipal employee, you may not participate as such an employee in any matter that might affect financial interests of you, your immediate family members, any business organization that you own or operate or that you're employed by, any business partners that you might have, anyone or any organization with whom you are negotiating for employment. You may not participate in those matters affecting their financial interests. Now, there is a process that's available for the town, for the appointing authority, because the law says you cannot participate in those matters. And so when we hear about these kinds of instances, we might hear the terms abstain or recuse. In our world, those two terms mean the same thing, but we understand they have a different meaning in a different context. But it basically means the public employee, when faced with a financial interest conflict, they're stepping back from the matter. They're not participating in the matter. That's what the law requires. But not all financial interest conflicts are significant. Some involve routine or administrative matters. And because there are those kinds of issues, the law has built in an ability for the appointing authority to waive the requirements, being you can't participate. Example, I'm a department head for the town. Say I'm the fire chief. And I have an immediate family member, a son or a daughter, who works in the department. Now, I didn't hire them. That would violate the nepotism section. I don't supervise them. That would violate the nepotism section. When they were hired by the town, I was not the chief, but I was a firefighter. I'm now the chief. They now work in the department. I'm a department head. One of the things I'm legally required to do as a department head once every 2 weeks is sign payroll. If I don't sign payroll, nobody gets paid. But if I sign payroll and I have a son or a daughter, an immediate family member working in the department, I'm participating in a matter that affects the financial interests of an immediate family member. It violates the nepotism section. But it's not that big of a deal. All I do is put my name on a line. I don't prepare payroll, staff does. It's a routine administrative matter. And although it implicates the conflict of interest law, in that instance, one of the things I can do is I can go to my appointing authority, the town administrator, with a disclosure. I file a disclosure that says, I have a financial interest conflict in signing payroll. I have an immediate family member working in the department. My appointing authority, the town administrator, then decides how to resolve the conflict. And I'm saying town administrator, I could be inaccurate. I don't know if it's the Board of Selectmen or the town administrator that appoints department heads, but whoever the appointing authority is, I file my disclosure with my appointing authority. They then decide how to resolve my conflict. I cannot decide how to resolve it. And they can do one of three things. They can take responsibility for signing payroll from me, and they can sign payroll. They can take responsibility for signing payroll away from me and assign it to someone else to sign. I can't do that. If I were to reassign my responsibility to someone else, I'm participating in a matter I'm not allowed to participate in. The third thing they can do is they can make a determination that my signing payroll is not so significant a conflict so as to affect the integrity of the services that the town can expect from me. A determination of that. If they make that determination constitutes a waiver of the nepotism requirements. I can then sign the payroll without violating the conflict law. My disclosure to my appointing authority and their determination, if they choose to make it, are public records and have to be preserved as such, so that when somebody gets the obvious idea that I'm violating the nepotism section and they go to the town, has this person filed a disclosure of this, that disclosure can be produced. If you are elected to your position, this provision is not available to you because you don't have an appointing authority. But we'll talk about what is available to elected boards. Think this. Say we have a 5-member planning board in the town. It's an elected planning board, and they decide projects that get built. And say Walmart wants to put in a big box store in the town, and they're going to put it right next to my property. As a homeowner, are my financial interests affected by that? Most certainly. Well, what if we have a 5-member elected planning board and 2 of my fellow board members also live in the neighborhood? They're also abutters. All of a sudden, we have 3 of 5 planning board members that have to abstain because their financial interests are affected. What do? Well, there's something called the rule of necessity we'll discuss momentarily. So there's no exemption here if you are elected to your position. If you are appointed to a board that has this kind of an issue, you go to your appointing authority, in most cases the selectmen, and they can decide how to resolve your conflict. The rule of necessity would only be available to elected boards. Also, if your financial interests are affected because you are an abutter, as in my example I just provided, or because it affects a business competitor, if it can be argued that your financial interests are affected in this matter that affects one of your business competitors, then this nepotism section applies. Here's a chart for immediate family members. It's you, it's your spouse, your parents, your spouse's parents, your brothers and sisters, your spouse's brothers and sisters, and your children. Those are your closest and relatives. You may not participate as a public employee affecting your or their financial interest. So it then begs the question, well, what about the other family members? We see immediate family members. It's defined in the statute. What about a matter that affects the financial interest of a non-immediate family member? Well, it's not the nepotism section that applies in that instance. It's the section for non-financial interest conflicts. Public employees can participate in matters affecting the financial interest of non-immediate family members, provided they first file a disclosure of that conflict with their appointing authority or with the town clerk if they're elected to their position. The rule of necessity is available to elected boards. If the board cannot achieve a quorum to handle a matter, look at my Walmart example. We have specific guidance that we put out to make sure that if an elected board is faced with this kind of a situation and they are considering invoking the rule of necessity, that they follow simple steps. Number one, that they get legal advice, either from town council or the commission's legal division, that invoking the rule of necessity is appropriate, because it can only be done as a last resort. If a board cannot put a quorum together because of financial interest conflicts, but it can delegate its authority to someone else, it must do so. Or if there's some other board that can take over in place of the affected board, that it do so. But if it's a last resort, there is no other workaround, and the board cannot put a quorum together because a sufficient number have financial interest conflicts, then the rule of necessity can be available. And it's simply an invocation. The rule of necessity does not appear in the conflict law. It's simply a process that the courts talked about in a decision, a conflict decision, where it said, basically the principle being, government operations have to have continuity, and where there are impediments, such as the conflict of interest law, workarounds have to be sought and used. And so the rule of necessity was espoused, where it said the board can invoke the rule of necessity and then everyone can participate, even those members with the conflict of interest. And so the rule of necessity is available as a shield for elected board members that might have financial interest conflicts, to allow them to participate despite the conflict. But we say take care and get legal advice, because it is possible to improperly invoke the rule of necessity. And if you improperly invoke the rule of necessity, you do not get to take advantage of that shield. We had a case involving a city council, 7-member elected city council. Very controversial development matter coming before the city council. 4 of those 7 members had conflicts of interest. 2 of them had financial interest conflicts that required them to abstain. 2 of them had non-financial interest conflicts that could be cured by them filing a disclosure. But when the matter came before the board, all 4 members said that they were abstaining due to conflict of interest. The chairman then invoked the rule of necessity. They all participated in the vote, and then we learned about it. And we said, you 2 had financial interest conflicts, you were required to abstain. You 2 did not have financial interest conflicts. You could have participated, provided that you filed a disclosure. That still left 5 members to handle the matter. Instead, you invoked the rule of necessity. You did so improperly. You 2 don't get the protection afforded by the rule. You violated the Nepotism Section, and so they were sanctioned for violating the Nepotism Section. What we say is boards should get legal advice, and then where it's appropriate to invoke the rule of necessity, for the record, for the minutes, the board members with the conflicts should disclose those conflicts. Why do they have a conflict? And then the board can invoke the rule. Any member of the board with a conflict can invoke the rule, and then all of the members can participate in the vote, even those with the conflict. They don't have to. The rule merely permits it. It doesn't require it.
Now, the rule of necessity applies to conflicts, not necessarily like a nepotism case. Did you mean that the 4 people all had nepotism? Or they had a conflict?
No, 2 of them had nepotism issues. 2 of them had non-financial interest conflict situations. So 2 of them had to abstain. 2 of them didn't have to abstain. They could have if they wanted to, but the board still had the ability to put a quorum together to decide the matter.
Rule of necessity could apply to just a conflict, not a nepotism case.
No, it's got to be a conflict of interest that requires you to abstain from a matter.
But it's not necessarily a nepotism case.
Well, that's generally what it is a nepotism case. That's the only section that requires you to abstain from the matter. Other sections involve conflicts, but they can be cured by filing a disclosure, and your participation is then permitted. But in a nepotism case for an elected board, there is no workaround. You are required to abstain, period. Okay, what happens if you need to abstain? Sometimes people get confused by that because they see different formats for board members who abstain from matters. Sometimes we see a board member sitting at the table saying, I'm going to abstain from this matter, and they remain at the table. Sometimes we see a board member that says they're abstaining from a matter, then they go sit in the audience, and then other times we see an abstention and then the person leaves the room. Which one is correct? A, B, C, or D, all of the above? And the answer is all of the above. The conflict law simply says you can't participate in the matter. It doesn't then describe what you have to do in order to not participate. It just says don't participate. Now, we see these different versions of abstaining, and I'm discussing it because sometimes we get complaints. Somebody will abstain and they'll remain at the table. They're complying with the law, but we'll still get a complaint. What does a complaint consist of? Well, they remained at the table. And we go, well, yeah, well, did they discuss the matter? No. Did they vote on the matter? No. Well, what did they do? Well, they glared at their fellow board members. Or they were changing hand signals or exchanging hand signals. Or by their very presence, it was intimidating to their fellow board members so that the other board members didn't dare vote against the person's interest. We get it. And it happens. Now, all the person has to do is not participate in any substantive way. Don't discuss, don't vote, don't lobby, don't do any of that stuff. And they're complying with the law. But while you're complying with the law, you may not be making the best decision to insulate yourself from a complaint to the Ethics Commission. And we get them. And you don't want to go through that process, because when we get that kind of a complaint, we're going to do what we need to do to verify that you didn't participate. And even though if we're doing our job correctly, we will get to that end game. We will find that there was no violation of the conflict law. Trust me, in my 20 years as an investigator with the Ethics Commission dealing with these kinds of cases, even when we found that there was no violation of the law, never once did any of the people I dealt with say, after the process was over, say, thanks, that was nice. Because it's not. It's intrusive. Arguably, it's unfair. But when we get those kinds of complaints, we review them, and what are we going to do? We're going to review the public record. We're going to talk to you. We're going to talk to everyone who was there. We are not going to go away until we are satisfied that there was no violation. And sometimes it's an intrusive process and it's unfortunate, but that's what's going to happen. So while you can abstain and remain at the table, you may not be doing everything possible to insulate yourself from a possible complaint, and going through that process is not advisable. But we'll get to the end game and we'll get to the right decision. Now, you then have instances where people abstain and they go sit in the audience. Now, why would they do that? Well, look at my Walmart example. Now, I'm on the planning board, but I have a financial interest conflict. I have to abstain. I can't participate as a board member, but Walmart's going to want to build this big box store right next to my property, and I have something to say about it. I might serve on that board, but I'm still a homeowner. I'm still a taxpayer. I'm still a voter, and I don't lose any of my rights just because I serve the town. I'm allowed to represent my own interests. And so while I have to abstain as a planning board member, I can remain in the audience, and when the public hearing occurs, I can be heard just like any other resident of the town. So that's acceptable, as long as I don't invoke my planning board position and I don't participate in the matter at the table. And then we have situations where people abstain and then they leave the room. And in fact, the court said, when considering this kind of a case, it said in its decision, the wisest course of action is to leave the room. Now, why would they say that if the law doesn't require that? Well, simply by leaving the room, you are doing everything you possibly can to insulate yourself from a possible complaint, where people might get the wrong idea, confidence in government erodes, and so forth. Because if you're not even in the room, nobody can then legitimately complain that you participated in a matter that you weren't allowed to participate in. Okay, that's the nepotism section. The financial interest conflict section. Now we get to a section dealing with non-financial interest conflicts. We call it the code of conduct section. This is a section that says any time a public employee is poised to handle a matter and some component of their private life is going to be affected, they have to file a disclosure to dispel the appearance problem. The statute says this: a public employee may not act in a manner in which a reasonable person, knowing all of the circumstances, could conclude that the public employee would act with bias. And it sets out a situation that says you're the public employee, you're poised to handle a matter, some component of your private life is going to be affected by that. In that scenario, a bias is created. It is always created. It cannot be helped. A reasonable person looking at the circumstance will wonder whether you're going to continue to do your job fairly, objectively, consider the matter on the merits, or instead whether, because this issue will affect some component of your private life, your judgment is somehow affected or impaired. And so the law says, provided that you continue to handle the matter objectively, you can participate in the matter, but you first have to file a disclosure. You have to put the cards on the table. Because if a public employee participates in a matter and some component of their private life is affected by that participation, and they don't disclose that, it's reasonable to conclude that they were biased, that they acted with bias, that their judgment was impaired. But as a matter of law, if a public employee, when faced with that situation, files a disclosure, that written disclosure dispels the appearance problem that's otherwise created, such that it is no longer reasonable to conclude that the public employee acted with bias. And that's what the effect of disclosure is under the conflict law, to dispel appearance problems. This section of the law also prohibits public employees from using their positions to secure benefits for themselves or others that they're not entitled to. Unwarranted privileges of substantial value. There's that $50 rule again. So to illustrate that, let me give you an example. I work in town hall. I have one job. I issue a permit. Anybody that wants my permit has to do two things. They have to fill out a permit application and they have to pay a permit fee. For the sake of argument, let's say the permit fee is $100. I got to get it over substantial value. One day, my Uncle Harry comes in and he wants a permit. And I'd say, Uncle Harry, today's your lucky day. Today you get the friends and family discount. Fill out the application, but you don't have to pay the fee, and here's your permit. In that instance, I've used my official position to secure for someone I have a private connection to, my Uncle Harry, an unwarranted privilege of substantial value not available to similarly situated individuals. Why is that? Because in my job, issuing a permit, everyone has to fill out the permit application and pay the fee. Where I've said that Uncle Harry doesn't have to pay the fee, I've conveyed a benefit that he's not entitled to, because in doing my job, I'm not allowed to give out a friends and family discount. Everything we do in government follows a rule or a process or a procedure or a statute or a regulation. And part of the reason is so that public resources are available to everyone on a fair, equal, open basis. Under the conflict of interest law, any time a public employee deviates from the rules, and as a result of that deviation, someone that they have a private connection to, like my Uncle Harry, benefits by $50 or more, it's an unwarranted privilege on its face. It violates the conflict law. The conflict of interest law also says that public resources, official resources, cannot be used for private or personal use. Public resources, anything paid for with taxpayer dollars. Private or personal use, anything not related to the conduct of the public's business. So this is a section that would say that if the town issues you a cell phone so you can stay in touch with the office, do you get to rack up hundreds of dollars in personal calls on it every month that the town has to pay for? No. If you're given a laptop, can you run your private business operations off of that town laptop? No. If you're given a take-home vehicle so that you can respond at a moment's notice on issues, do you get to take that take-home vehicle up to your ski chalet in Vermont every weekend during the winter? No. Any abusive private use of a public resource violates the conflict of interest law. This section also covers political activity. Public employees may not use public resources for private or personal use because that involves a use of one's official position to secure an unwarranted privilege of substantial value not available to similarly situated individuals. And so this covers political or campaign activities because those are private things. That's not the public's business. The premise under the conflict law is this: elections, ballot questions, referendums, overrides, all of that stuff, that's the public's business. The people decide elections, not government. So government is not in the business of influencing or deciding elections. Therefore, government resources cannot be used in connection with campaign or political activity. And when we're talking about it, it means use of public resources involves on public time, in public buildings, using public equipment and supplies. Public employees may not use any of that in connection with campaign or political activity. Also, soliciting campaign support. If you issue permits and you leverage issuing the permit or approving the permit or an inspection or any component of your official duties, if you try to leverage that for somebody's campaign support, that violates the conflict of interest law. Oops. Going back to the code of conduct, disclosing confidential information is also restricted under the conflict law. Public employees who receive or review confidential information may not disseminate that information to anyone not authorized to receive or review it. Confidential information. Well, we work in government. The premise is any document created by government is a public record. But we know that's not the case. There are certain public documents, I shouldn't say public documents, documents created by government which are not public records. Personnel records, student record information, medical information, litigation information, law enforcement information. If somebody's applying for a town job and they have to pass a query check, query information. Exempt from disclosure under the public records law. Now, the Commission is not necessarily concerned with any disclosure of confidential information, any inadvertent disclosure. But if a public employee disseminates confidential information to anyone not authorized to receive or view it, and they do so to further a personal purpose, that's what would get our attention. And we had a case involving a district court officer. Now, court officers don't have access to query information. But one day this district court officer went to her best friend in the court, Mr. Probation Officer, and she asked him to run a query check on someone. Now, probation officers have access to query information. Now, this court officer had a relative who was running for an election locally. And so one day the court officer went to the probation officer and asked if he would run a query check on a person who was the relative's opponent in the upcoming election. The probation officer thought it was a legitimate business request and so ran the record, came up with a record, an arrest record, gave it to the court officer thinking it was official business. The court officer gave the record to her relative, who then released it to the media. When we learned about it, we said, court officer, even though you're not authorized to receive query information, once you did, you were obligated to keep it confidential. Instead, you disseminated it to somebody who was not authorized to receive it, and you did so to further a personal purpose. And so the Commission took action in that instance. This requirement regarding confidential information survives your public employment. So even after you would leave your position, what you learned was confidential, you have to keep confidential, and if you don't, the Ethics Commission could take action, even though you're now a former public employee. Okay, there are several sections of the law that apply to us after hours. I've talked about the gift restrictions, the Nepotism Section dealing with financial interest conflicts, the Code of Conduct Section dealing with non-financial interest conflicts. Those apply to us as we're doing our job. There are a couple of sections that apply to us after hours. In other words, after the day is done, we have private interests, family interests, business interests, what have you. And if those interests also involve the town, the conflict of interest law might apply. It might impose a restriction. Also, the conflict of interest law regulates or restricts whether you can be a municipal employee and hold more than one municipal position, or be a municipal employee and also do business with the town by having an interest in a vendor contract to provide goods or services. So we'll tackle each briefly. These are the most complicated sections of the law, so all I'm going to do is hit the highlights. If anything resonates, this is where you need to contact our legal division for specific advice. It says agency up here, but when you took the online training program, we called it duty of loyalty. The lesson was duty of loyalty or divided loyalties. The conflict of interest law says that a municipal employee may not act as agent or attorney for anyone other than the municipality or receive compensation from anyone other than the municipality in connection with any matter in which the municipality is a party or has a direct and substantial interest. What the hell does that mean? By virtue of your position as a municipal employee, by virtue of your appointment, the law imposes a duty of loyalty on you to the municipality. You have to hold the municipality's interest paramount. And so the conflict of interest law says you cannot represent private parties, private interest in matters where the town has an interest because it compromises your duty of loyalty to the town. You would have a duty of loyalty to some private interest. It is not permitted except in limited instances. There is a provision in the law, however, that says that not all municipal positions are paid positions. By necessity, people who serve the municipality also have to have private business interests. And sometimes those private business interests might also involve the town. So there is a provision in the conflict law that says that as to certain municipal positions, the town can designate those positions as special municipal employees. Any municipal position that is unpaid is eligible to be so designated. Any municipal position that is paid, but it's paid for at less than 800 hours in a year, that's eligible. Any municipal position which by the nature of the municipal service provided allows for private employment during normal business hours, and that's where all your boards and committees come in, because you do your work for the municipality at night. Those positions are eligible to be designated by the town as special municipal employee positions. If you occupy a special municipal employee position, the duty of loyalty applies less restrictively. You are allowed to represent private interests before the town or to receive compensation from a private party in connection with a matter where the town also has an interest, as long as it doesn't involve the board or department that you work for on the municipality. It can involve any of the other ones not related to your municipal position. There are also exceptions to the rule. You do not violate the duty of loyalty requirement if you're representing someone in connection with a personnel or disciplinary issue, as long as you're not paid for that representation. You do not violate the duty of loyalty section if you're providing sworn testimony or statements in connection with any judicial or quasi-judicial proceeding. You don't violate the section if you're representing family members. If you have a family member that has an issue with the town, you can represent their interest, provided that your appointing authority approves of you doing so that there can be a review that makes sure that as a municipal employee, you don't have responsibility for that matter as well. And then there's also an exception that says you can be a municipal employee and pull permits on behalf of others. You can be a municipal employee and be a contractor. If you pull a building permit, if you're a contractor, you are acting as the agent for the property owner. The conflict law says municipal employees can pull building permits, wiring permits, gas and plumbing permits, septic permits, as long as a municipal employee, they're not employed by the permit granting agency or an agency which oversees the activities of the permit granting agency. So I could be a full-time police officer or a firefighter and also have a building contracting business where I'm pulling permits in the town, and that's allowed. But I couldn't necessarily be the building inspector and then pull building permits to do work for property owners in the town. That wouldn't be allowed. The second section dealing with contracts reads simply. It says, a municipal employee may not have a financial interest in a municipal contract. Well, what does that mean? Well, a financial interest in a municipal contract can come in one of two ways. Additional municipal positions, vendor contracts to provide goods or services. Generally, the conflict law says if you're a municipal employee, you may not hold an additional municipal position or you may not have a financial interest in a municipal contract unless you qualify for an exemption. There are a ton of exemptions available. We all know of certain municipal employees that have more than one position. And one of the exemptions is you can serve in any number of elected positions, whether they're paid or not, without restriction, because you're deemed to have a contract with the municipality if you are appointed to your position, but not if you're elected. You serve in the position 24/7. It doesn't involve a contract. You are not required to do anything in connection with that elected position. Did you have a question?
Yes, sir. As an appointed official, is it okay to have an interest or a financial interest in a contract in another municipality, not your own, as a matter of your business, involved in consulting or sales?
Sure. And the answer, so the question is, you're a municipal official in this municipality. Can you have business interests that involve contracts with neighboring municipalities, for example? And the answer to that question is yes, because it does not violate the duty of loyalty that you owe to this municipality. So where we have a situation where you have a building inspector and that building inspector is also a contractor, we tell them, you can't do any contracting business in the town in which you serve as building inspector, but you can go do the work in all the other towns without restriction, as long as it's not double dipping. In other words, when you're on the clock as building inspector, you can't be working your private job in some other town. Believe me, we get that. So, there are, the rule is you cannot unless you qualify for an exemption, and there are numerous exemptions. One being, if you occupy a position that is a special municipal employee position, you can serve in other municipal positions as long as you file a disclosure with the town clerk's office that you have this interest in this additional municipal contract. There's also, through our regulatory exemption, a provision that says you can be a municipal employee and be appointed to an unpaid municipal position as long as you file a disclosure with your appointing authority in your paid position. So there are numerous exemptions. So there's no hard and fast rule to tell you what is allowed and what is not. It's you cannot unless you qualify for an exemption. Did you have a question? Yes.
What if you didn't know you needed to file the disclosure? Can you file it after?
Well, it doesn't technically comply with the law because any disclosure filed to comply with, and the question is this: what if you hold an additional position and you needed to file a disclosure but you didn't? Can you file the disclosure late? And the answer is, while it doesn't technically comply with the law, better late than never. If we learn about those situations, this is generally a very complicated section of the law. We don't take enforcement action under this section unless there's an egregious violation. In situations where we learn that somebody is holding two positions and the law otherwise allows them to, provided that they file a disclosure, but we learn that they didn't file the disclosure, we're going to resolve that kind of an issue privately. We're going to contact you. We're going to tell you, look, to be technically compliant, you need to file this disclosure. Please do so within 30 days. So we only take enforcement action in egregious, self-serving kinds of violations. In the technical ones where there's genuine confusion or complication, we're going to work with public employees to get them into compliance. So the issue is, what happens if you're not in compliance? Well, as long as you're eligible to get into compliance, we're going to work with you on that. But there's a provision in the law that says, for example, that you can be a municipal employee and also serve on the Board of Selectmen under a special carve-out that says municipal employees can also serve on the Board of Selectmen provided that they observe three conditions. One, they can only take one salary. So say you're a police officer. You can serve on the Board of Selectmen, but you have to make that very difficult decision. Do you continue to accept your police salary or do you instead accept the stipend? But you have to make that decision, because you can only take one. The second thing is, while you're serving in that dual capacity, as a selectman, you cannot participate in matters affecting, for my example, the police department. And then the third condition is, you're ineligible for appointment to any other position while a selectman and for 6 months after you leave the board. And that's where sometimes public employees get hooked in. We had a case involving, and I have to make sure it doesn't involve this town, it doesn't. We had a situation where a police officer, he was a command rank officer, and he also ran for and won a position on the Board of Selectmen, and he was serving in that capacity. He only took one salary, and then as a selectman, he didn't act in matters within the purview of the police department. But then the police department was expanding and the town wanted to create a deputy chief's position. And he was the senior command rank officer as a lieutenant. So when the position was created, he normally would have been selected for that position. And he was selected for that position. And then we learned about it and we said, oh no, you give up that position right now. There was no workaround for him. He couldn't hold the position. He should have contacted us first before doing that, so he was fined for violating the conflict law. We made him give up the position and we fined him because as a selectman, as a police officer also serving under the selectman's exemption, he was ineligible for any other appointment. And he's like, well, wait a minute, this is a promotion within the department. This is civil service. Civil service law does not trump the conflict of interest law. If you're serving in that dual capacity and you're availing yourself of that exemption, it has incumbent risks as well. Also, trick question for you, just to see who's still awake. Not that we hold it against you. Because the information is so dry, admittedly, but we want to try to give you as much information to sort of translate the statute. But, okay, so you're a police officer, you're also serving on the Board of Selectmen. The chief retires. Can you participate in the selection of the new chief as a selectman? Most people say no, but I said it's a trick question. The selection of a police chief is not a matter within the purview of the police department. It's a matter within the purview of the Board of Selectmen, so you can serving in that capacity. Okay, those are the two restrictions that apply to us off the job. We now have a restriction that applies to us when we leave government, so-called revolving door restrictions. The premise being this: you're a municipal employee, you leave municipal service, you now want to represent a private interest before the department you just left. A new employer, or if you formed your own firm, you want to represent a client of the firm before the department you just left. Can you do it? The answer to that exciting question is, it depends. So let's examine the conditions that apply. We look at, or the conflict law looks at, what you do as a public employee. What did you handle as a public employee? It also looks at what is it that you did not handle, but it was nonetheless under your official responsibility as a municipal employee. Illustrate. I'm a DPW worker. I'm a laborer. I go into work. The foreman gives me my assignments. I carry out my assignments. You cannot distinguish between matters that I handled versus matters that were under my official responsibility. They're one and the same. But I work for the town for a number of years. I move up the organizational chart. Now I'm the DPW director. Everything that comes into the DPW is a matter under my official responsibility as the department head. But I don't handle everything that comes in. I have staff to deal with stuff. I deal with the high-level stuff. You can distinguish between matters that I handled versus matters that I did not handle, but they were nonetheless under my official responsibility. So I then leave the DPW and I form my own consulting firm, and I now want to represent a client before the DPW. The law imposes a restriction. It looks at what is the nature of that representation. What is it in connection with? And the law says there is a permanent restriction on you from representing private parties before your former agency on matters that you handled while you were a municipal employee. A permanent restriction. You may never, when you leave municipal service, represent private parties before the town in matters that you worked on as a town employee. And then there's a one-year cooling off period or one-year restriction on matters that while you did not handle them, they were nonetheless under your official responsibility. You leave the town, you wait 1 year, you can then represent the client before the DPW. If neither condition applies, the reason for that representation is not in connection with the matter that you handled or in connection with the matter that was under your official responsibility. I can leave the DPW today and represent the client before the DPW tomorrow, as long as neither condition applies. There is also a restriction on partners. If I form my own firm and I'm a partner in a firm and I'm faced with that permanent restriction, my partners have to observe a 1 year period before they can represent the client. Where I have a permanent restriction under the conflict law, they have a 1 year restriction. If I have a 1 year restriction, my partners have no restriction. If you are a member of a board and a vacancy, a staff paid vacancy, on a position that your board appoints comes available, can you serve in that position? No, unless. Say I'm on the Board of Health, and the health agent resigns, and the Board of Health appoints the health agent. Can I be the health agent? I cannot be a Board of Health member and the health agent. What I have to do is I have to resign from the Board of Health. I can then apply for the health agent position. My fellow board members cannot consider my application until I've been off that board for 30 days. They can then consider my application and all the other applications, and if they appoint me, I can then serve as the health agent. That's separate from the selectmen's exemption. For people who are town employees and also serving on the Board of Selectmen using the selectmen's exemption, there's that 6-month waiting period. They are ineligible for any other appointment in the town while a selectman and for 6 months after they leave the Board of Selectmen. But for everyone else, 30 days. You leave your position, and then you can apply for a staff position that's appointed by your board, and your fellow board members have to wait 30 days before they can consider your application. Okay, in 2009, the conflict of interest law was amended significantly. One of the things that was done was an increase in the civil penalties from $2,000 to $10,000 for all sections of the law except for bribery. The new Code of Conduct section prohibits gifts of substantial value given because of official position. There's also now a false claims provision in the conflict law that wasn't there before. Now, a false claims is not inherently a conflict of interest. A false claim is a fraudulent claim for compensation submitted to a public employer. Why would they put it there? I don't know. But we have a case now that would illustrate the need for it. We had a case years ago before this section was inputted where we had a police officer who was approaching retirement and trying to figure out a way to enhance their retirement benefits. They took on a second full-time public position. Not with their same municipality, the conflict law prohibited that. But he was approaching retirement, and when you look at your retirement benefits, you're looking at your age, how many years of service you have, the highest average salary for the last 3 years or highest 3 years. And he couldn't affect his years of service or his age, but he was going to try to leverage his average salary. So he was a full-time police officer in this municipality. He took on a second full-time position with the county sheriff. Sheriff's departments are now state agencies, but at the time they were county agencies. The conflict law didn't restrict a person from serving in more than one position at different levels of government, as long as there was no double dipping going on. He worked those positions for 3 years, then retired, got a very greatly enhanced retirement benefit. What we learned after the fact was, during the last 2 years of that 3-year stint, he banged out sick 200 times from either of his public jobs to go work the other job. Our enforcement division learned of the conduct and brought an action against him under the theory that he used either of his public positions to secure a benefit he wasn't entitled to. Our commission dismissed the case. It said, enforcement division, you're misreading the statute. When somebody calls in sick, they're not acting in their official capacity, they're acting in their personal capacity. So the case got dismissed. But now there's a false claims provision in the conflict law that says you submit a fraudulent claim for compensation to a public employer, it's now a violation of the conflict law, subjecting you to a $10,000 civil penalty. You bang out sick 200 times when you're not sick, guess what's going to happen? The commission can not only impose civil penalties of up to $10,000 for the violation, it can issue any such orders to affect the intent of the statute, those orders having the full effect of court orders. You know what that does now? It puts restitution and disgorgement on the table. We get that case today. Entirely different result. It's going to be a fine. It's going to be pay back all the money you weren't entitled to, or at least pay back all those sick days that you took that you weren't sick. Significant dollars. So I raise this issue, false claims provision, because it can potentially have a very significant impact for what might seem like innocent occurrences where somebody is padding an overtime record, padding a comp time record, or an expense report, or a disability report, or it might be small dollars. The potential penalties, if you get caught now, are very significant. Okay, let me just step back there. Mandatory training. This is not substitute for the mandatory training. Does anyone have any questions for that? Other than that, the most important slide is, I hope you can appreciate it gets fairly complicated. I hope you can also appreciate the value of making sure you know what the compliance rules are before you engage in any conduct which might implicate the statute. Okay, any questions? Seeing none, thank you for your kind attention and have a good evening.